Mr. Muller's case is 25M1510. Mr. Muller, good morning. Mr. Guard, good morning to you. Case comes on for a continued arraignment. I think there's a pending motion.
Yes,
If I remember. Let me start. I think I've read the defense position based on the motion. Okay. Let me just hear from Mr. Muller then. Mr. Muller, you understand the motion Mr. Guard filed?
Yes, sir.
What's your position on the motion?
There was another law firm that had called me telling me they wanted to take the case.
Okay.
They told me that I had to fire him before I hired them on.
Okay.
Then when I called them back and I had let them know that I had let him go, that they wanted $6,000 from me.
Yeah.
So now I don't have representation. So.
Well, you currently have representation. Mr. Guard is currently your attorney.
Uh-huh.
There was a motion filed asking to withdraw to remove him from the case.
Uh-huh.
I haven't granted that motion yet.
Yeah.
I wanted to talk to everybody before we take that step.
Yeah.
So what is it that you want to do as far as representation goes? What do you want to do? You can just talk to me. Just tell me what you're thinking.
Well, honestly, I wanted to ask for recusal today or demand recusal on violations of oaths of office. But
So hold on, recusal, have me recused?
yes, sir.
Okay, well, let's talk about your representation first.
Okay. Yeah, I wanted a lawyer.
Okay.
That's moving forward. I wanted a lawyer, but
Okay.
now I want to represent myself, sir.
Okay, I want to make sure I followed that. You had wanted a lawyer,
Yes.
applied for the public defender,
Yes,
you
sir.
got alternative defense counsel,
Now I'll just represent myself, sir.
looked into private counsel, probably going to be too expensive, likely.
Yes, sir. Yeah.
And you want to go forward and represent yourself.
Yes, sir.
You can do that. Of course, you know that. You have the right to do that.
Yes, sir.
And we're not set for a trial or anything yet. Are you hoping to set for trial as well today?
Yes, sir.
Okay. We're going to have to talk a little bit about that then. Before I do that, though, let me just check. Mr. Guard, I've read the motion. Any other record you want to make? Mr. Mueller does not want to be represented by an attorney. All right. I'm going to release you. I'll grant the motion to withdraw based on Mr. Mueller's request. You are no longer his attorney. You're free to go. Or if you have another case, stick around. So, Mr. Mueller, now you, like you said before, predicted you now are representing yourself, no attorney.
Awesome.
Okay.
Thank you.
Now, what do you want to do with your case? I heard you say set for trial.
Yes, sir. I mean, I would like to just throw it out, to be honest. I mean, this should have been thrown out at Deacon's closet. It's a violation of a lot of rights, sir.
Can I just pause you on that?
Yeah.
I apologize. And I know you have some issues, legal issues you want to bring up. This is not the right moment to do that.
Yes, sir.
So that's why you want to go this direction. I want to just deal with the one issue right now, which is, do you want to set the case for trial today, or do you want some time to negotiate yourself with the district attorney? Or
Well, I haven't consented to any of this, sir. Everything I've done up to this point has been under duress and coercion.
so let me try it again a different way. Do you want to set for trial, or do you not want to set for trial?
I would not like to set for trial.
Okay.
I mean, I don't consent to any of this. So
Hey guys, welcome back to today's video. Now this one is something else. We've got a self-proclaimed sovereign citizen in court who genuinely believes he's mastered the legal system after spending some time around books and picking up a few buzzwords. What started with, I thought I was just being funny, I didn't realize it was such a big deal, quickly turns into courtroom chaos. So buckle up, because this is about to get interesting. Let's get into it.
What I'm going to do today then is I'm going to enter a not guilty plea on your behalf.
well, I haven't entered a plea, sir.
I know, I'm doing it on your behalf.
10-4. Or you don't use 10-4 here, sorry.
I understand it.
Yeah.
Speedy trial starts today, and that's preserving your right to a speedy trial. I'm now compelling, on your behalf, it's what your attorney would have done for you, compelling the prosecution to resolve this case within 6 months of today. That's preserving your right to a speedy trial. That deadline will be April 27, 2026. We're not setting it for trial yet. You're not asking for a trial date, but we're now pushing the DA. Say, you got to take care of things. And if they don't resolve the case at a trial or through a plea bargain, the case will be dismissed.
Yes, sir.
Okay? So we'll set it for a pretrial conference. How much time do you think is useful for you to figure out how you want to proceed with the case.
Well, I think me and the DA are going to have a conversation
Right.
after this, so thank you.
Okay.
Yeah, we'll figure it out, and whatever date you deem.
Sure. So we can do 4 weeks from now. That gives you just under a month. Is that too much time or not enough?
I mean, I have to be here for another case anyway. I'm a witness in another case, so
Okay.
that's the 9th of December. So I'm good. I got to be here till the 9th of December anyway. So
I'll be in town, you mean?
I have to be in town for
Okay.
for that.
So let's do the 24th then of November.
Okay.
Let's do November 24. We'll set that at 9 a.m. It's an in-person appearance right here in Division 7. Between now and then, if you want to talk directly with the DA, make sure you have their contact information, email, phone number.
Got it right here.
Yep. And I know I've talked to you about this, but I just want to make sure, you don't have to talk to them. You don't have to.
I would rather reach an agreement, sir. It's gone on for way too long. I'd rather gracefully step out of the arena than I want to get back to the garden. I'm a healer, and like I've been doing a lot of work in this town for the last 2 years, off and on. So I don't want to be in spaces that harden my heart. So
I got you.
I just want this to be done with and
Okay.
move forward with my life and heal myself and allow others to heal.
And I appreciate that spiritual position.
Yeah.
I'm speaking from a slightly different legal position. And I think you know this. I just want to say it out loud.
I can't like negate who I am. So
I got you. I'm not asking you to.
Yeah.
That's the prosecutor. They're not your attorney. You don't have to admit any facts or say, I was there at Deacon's Closet or this happened, but this didn't happen. You don't have to do any of that because what you say can and will be used against you. That's the prosecutor.
Well, yeah, I already heard the plea deal from my previous attorney. So, I mean, as long as we can reach an agreement, as long as we can reach an agreement, that's fine. So,
Okay.
Yeah.
If you can't reach an
not,
agreement, we'll talk about it in November. We'll talk just like this.
Cool.
Again, there's no surprises.
Yes, sir.
I'm going to talk to you however I need, to get the information to you. So if we don't reach an agreement, it's okay. There's other steps and we'll talk about them. Okay.
Thank you.
All right. Anything else, Mr. Mueller?
That's it.
All right. Thank you, sir. I appreciate it. Have a good day.
Now, unfortunately, your consent isn't needed. I didn't exactly sign up to hear this level of nonsense either, but Skeptic dragged me into it, and now my ears are filing for workers' compensation.
Mr. Mueller's case 25M1510. Mr. Mueller's case comes on for a pre-trial conference. Mr. Mueller here, pro se, without an attorney. Mr. Mueller, good morning, sir. Let me check in with the DA first. I'll come to you second. Okay. DA?
Yes, Your Honor. I conveyed the offer, and he informed me that he would like to go to trial as a pro se individual.
Mr. Mueller, is all that correct?
Yes, sir.
I have a speedy trial date of April 27, 2026. Does that check with both parties?
Yes, Your Honor.
I'd like to get out of town sooner than that. Is there any
Oh,
way
no,
that-
that's not the trial date. I'm sorry, sir. That's the speedy trial deadline date.
Oh, okay.
6 months from the date we entered the not guilty plea
Okay.
last time. That's just the deadline by which this case has to be resolved.
Okay. Thank you.
I'm just making sure I
Gotcha.
wrote it down right. Everybody agree?
That's
Yes.
Okay. No, we're going to get the trial way sooner than that.
Okay.
That's way too far out. All right. And I don't know if you put it. No, I don't see it on my notes last time. Would you put the offer on the record?
Yes, Your
please?
Honor. The offer is to plead guilty to petty offense trespass and close with conviction.
Mr. Mealy, you understand that offer in the case?
Yes, sir.
Okay. And you understand this. I have to advise you of this. So I don't mean this to sound like anything other than me making sure you understand the decision you're making.
I'll let you talk.
Thank you. I've had people who took this the wrong way.
Yeah.
And I have to advise you. I have to make sure you understand if you go to trial,
Mhm.
as you're asking, and if you are convicted, I'm not saying you would be, but if you were
Mhm.
convicted of the top count, class 2 misdemeanor, obstructing a peace officer, the worst case punishment you could face, and I'm not saying you would face this,
Yeah.
but the worst case you would face is up to 120 days in jail
Yes, sir.
on that conviction.
We've already talked about that. Yeah.
Yep. Versus the plea offer here, which would be a petty offense conviction and no additional sanction. You understand the difference between those two things?
Yes, sir. I'd just like to be heard. Yeah.
I got you.
Yeah.
No, I got you. That's fine. The only reason I had to do that is because there's been appellate cases where somebody who's gone to trial they were convicted, and then at the end, after the conviction, said, "Well, I didn't know
Yeah.
what I was facing. I didn't know that I was exposed to this worse sentence, and I would have taken the petty offense plea."
Yeah.
You're not in that camp. I know that.
Yeah. I would prefer to be heard over the 3 months. I'm well, more than willing to take the 3 months just in order to be heard, sir.
What do you mean through? Oh, 3.
Yeah.
Oh,
yeah.
I'm sorry.
I'm willing to put that on the line is what I'm
The
saying.
penalty.
Yeah.
3 months would be 90 days. 120 days is 4 months of
That's
potential incarceration.
Still okay.
And again, I'm not saying you would face that. It's just the worst case.
Yes, sir. Thank you.
I got you.
All right, that wraps up year 1. Now, I heard him call himself a healer, but there's no way I'd trust someone who clearly can't even cure his own stupidity. Seriously, this guy's bad decisions go so deep that even Mariana Trench would probably say, that's a bit much. Maybe that's where his logic disappeared in the first place. But now, it's time for his next hearing, where the prosecution offers him an unbelievably sweet deal. The problem, you're also about to witness him unlock an entirely new level of stupidity.
So let's get some dates then with that April deadline, much sooner than that. When are you thinking of getting out of town, Mr. Mueller? And you mean moving or just traveling?
I'm just traveling.
Okay.
So I'm a nomadic. So
How soon would you like the trial?
as soon as possible, really.
Okay. Do you want a motions hearing, a constitutional motions hearing, or anything like that?
I don't know the difference between that. So constitutional. Sorry, repeat that.
Yeah, sure. Do you have any motions you wanted to file in the case?
No.
Okay. You just prefer go right to trial?
Yeah.
Okay.
Yeah.
I'm asking because if you wanted a motions hearing, I'd set a motions hearing, then a month later set a trial. If you want to do the trial, we'll try to get it as quickly as we can.
Just as quickly as we can. Yeah.
Okay. Yes, and you'd like a trial to a jury,
Yes,
not
yes.
to the court.
Yes. Yeah.
Jury trial. You got
Yeah.
it.
Thank you.
Can the people do the 16th of December? I got to tell you this. I've set quick trials. I've never set one this quick.
Cool. Yeah. Let's go. Yeah.
So the only issue with this is a couple issues. One, DA, you obviously have some police officers that you need to subpoena. So they say they're available, but they have to check with the witnesses I suspect that they'll have and make sure those witnesses are available, especially over that kind of holiday period of time.
Yeah.
If possible, they might tell me by the end of the week, Judge, that date actually doesn't work. We need a different date.
Okay.
So that's possible. So I don't want you to lock that in.
Okay.
In pen, put it in pencil. The
Yeah.
second issue that we have is I want to make sure that you're good with that date, that you have everything you need to be ready for trial. And it's just a few weeks out.
Yes, sir.
We'll talk about that just a little separately.
Okay.
But for right now, you're good with the December 16 and or 17, because I set it over a 2-day period of time. Tuesday, Wednesday. Good for you?
Yeah, that's fine, sir.
Okay. Here are the dates and times. You might want to write these down. You got a pen?
I'll just write it down on my phone.
Okay. So the trial will be December 16 and or 17. That's Tuesday, Wednesday. For right now, plan on 8 a.m. in person right here. Got it?
Thank you, sir.
Continuing, I'm going to set what's called a court's disposition deadline. That's a cutoff deadline. I know you don't want to enter into a plea bargain, but I find it's useful just to have a deadline anyway.
Okay.
If you want to think about this, or if you wake up one day and you say, I think I'd rather just
Take the charge and
take
get out
the
of
petty
here.
and get out of here. Exactly.
Yeah.
I'll give you until December 8. That's a little over a week before the trial.
Thank you.
December 8.
Thank you.
That'd be the cutoff. You don't have to show up in court by that deadline. But
Understood.
if you want to make some plea bargain or you negotiate something better,
Okay.
all you have to do is either let me, the court, know directly, or let the DA know directly, and they'll file something and let me know, and we can vacate the trial so we don't bring jurors in,
Gotcha.
and we can resolve it on a different day. But I just want that decision must be made by the 8th, and I have to hear about it by that deadline.
Okay. Thank you.
Sure. Continuing. There's what's called a Rule 16 deadline. I'll set that for December 1, 1st of December. That's a week from today. And you have obligations on this day. The DA does too. December 1, both parties must file with the court any witnesses you have that you intend to call, expected witnesses, including any expert witnesses. I don't suspect either side will have experts in the case. Let me just ask, DA, do you expect any experts in the case?
Give me 1 minute, Your Honor.
Sure. It's a alleged trespass obstructing.
Assuming no, but let me double check.
Okay.
No, Your Honor.
Okay. Mr. Muley, do you expect to endorse an expert or bring in an expert witness to talk about something?
Not that I know, but now that you've mentioned it, I probably should.
Maybe.
I'm gonna look into it now.
I told you his stupidity somehow managed to sink even deeper. The deal on the table was simple. Plead to a petty offense and walk away. No fines, no jail time, done and dusted. But instead, he's choosing to drag this to trial, where he could be staring at up to 4 months in jail plus fines. That's the kind of decision-making you make when you run out of milk and think Elmer's glue belongs in your cereal.
But the deadline to do
16?
the deadline to do that would be the first. No, the
Oh.
trial is the 16th.
Yeah, okay.
First, you have one.
I'm sorry, I heard the rule of 16 and my
that's,
brain.
that's Rule 16. That's the rule number.
Gotcha.
It's a standard deadline.
Yeah.
I'm setting that on December 1st. So 1 week from today, you must tell me
If I'm
file with the
bringing
court.
any experts.
Not only that, but any witnesses you have. So
Okay.
any regular witnesses. I got a buddy who was there, who saw
Yeah.
everything happen.
Yeah.
If he or she's going to be here testifying, you must endorse that person, meaning write their name down, their contact information, and file that with the court. Experts are people who are not necessarily witnesses that saw something or heard something, but they could illuminate some more complicated topic
Yeah.
or subject for the jury.
Civil rights, yeah.
I wouldn't have a civil rights. It's not people to eliminate the rule of law. That's a different thing. That would be me. It would be a more of a factual thing. And that's why I said to the DA, I don't know that there's any factual issues that require an expert in the case. But if you could think of one,
Okay.
you're welcome to file one. I can tell you for sure there will not be any experts who educate the jury on areas of law.
Yeah.
That's not an appropriate use of an expert witness.
Hmm.
Okay.
Okay.
But
Question. Sorry, then this may be.
it's okay.
But am I allowed to explain law to a jury?
No, what you can do is, well, a couple things. One, I will give the jury the rules of law that apply to this case. I will do that. I'll do that in writing. You have the ability to weigh in on what you believe the rules of law that they should be instructed on are. You get to help or at least provide input as to what the rules of law you think need to be highlighted to the jury are. And I'm going to get to that. I haven't even talked about that
Okay.
yet.
All right, I'll let you get through it.
I will instruct them on what the law is. Secondly, though, you may comment on
Thank you.
on those rules of law for sure during your closing arguments in
Okay.
the case,
Okay.
for sure.
Okay. That makes sense.
All right, so that's the Rule 16 deadline. Witnesses provided to the court. Any expert witnesses, provide them to the court. Additionally, you have another obligation that's you must provide by next Monday, the 1st, what's called your defense, the nature of your defense, the nature of your defense. Now, listen carefully. That's not what the whole story of your defense or why you think you're not guilty factually. It's just legally, what's the nature of your defense? For example, Judge, I'm not guilty because I wasn't me. They got the wrong ID, wrong person. Or, Judge, I'm not guilty because the DA can't prove the elements of this charge beyond a reasonable doubt. So maybe I was there, maybe I wasn't, but the DA can't prove the charge. That's what's called a general denial, not a specific denial. Or I'm not guilty, maybe not, doesn't apply in this case, but maybe I'm not guilty because self-defense. Yes, I did this. I hit somebody, but I did it defending myself, which means you're not guilty.
Yes, sir.
That when I say nature of defense, I mean just a phrase like that. General denial, self-defense,
That's also December 1st.
December 1st. You have 1 week to
Thank
provide that to the court.
Can I just do that with the clerk's
Yep,
office?
you can file it right with the clerk's office. Yep. That's the Rule 16 deadline is next Monday for those witnesses, experts, and nature of defense.
Thank you.
Got it?
Appreciate
Yeah, somebody needs to bring in an expert on the most annoying laugh ever recorded. Actually, scratch that. We don't need a laugh expert. We need an oral exorcist and a fresh set of eardrums. I'd genuinely rather sit through a 2-hour documentary on paint drying narrated by a guy whispering about wallpaper textures than hear that cackle one more time.
Now, there's another thing we need to talk about. I'm going to issue, can you actually do it just in writing? Print it out? Correct. Oh, you've already got
on top of it.
read my mind. Most people get that electronically. I want you to get a physical copy so that you don't have to wait for it in the mail or something like that.
Okay.
So that's what's called a case management order or my trial management order.
Okay.
It lays out a lot of rules about just procedures on how to get through trials efficiently. And it's not just for you, it's for even attorneys as well.
Yeah.
There's a couple things I want to highlight in there. You'll read it, but I want to highlight it for you as well.
Okay, we can go over.
The Wednesday before trial, and that Wednesday is December 10. You must provide, and the DA as well, you must provide 3 things directly to the court. One, what we call motions in limine. Motions in limine. A motion in limine is a motion regarding an evidentiary issue or some other issue that will affect how the trial goes. Not a constitutional motion or a motion to dismiss or something like that. It's just if you have a question or a concern about, say, evidence in the trial, judge, the DA has body camera evidence, and I think there are clips on the body camera that shouldn't come in for one reason or another.
Mhm.
That's a good topic for a motion in limine, meaning we could talk about it before the trial, so we're not arguing about how to edit a video during the middle of a trial,
Okay,
something like that.
okay.
If you have issues like that, or the DA, they must file that motion in limine by Wednesday before trial, noon, it says on there, so that I can review that and prepare a ruling on that, so we're ready to go for trial.
Okay.
So 3 things, motions in limine. The second thing is an updated witness list. So on Monday, if you remember the 1st, you're going to give me all the witnesses you have.
Mhm.
Then the Wednesday before trial, you will tell me exactly the witnesses you are more likely intending to call. Sometimes people might say, I have these 5 witnesses, but then as you get closer to trial, you're like, you know what? I think I only need 3 of these witnesses. The DA does this all the time. They say, we have 5 witnesses, judge. We figured out 2 of the police officers don't need to testify. We're just going to use 3 witnesses.
Mhm.
That's what you need to tell me Wednesday before trial. Who are you really going to call? Because I just need to manage the timing of the trial. How many
Got it.
witnesses am I going to have?
Got it.
So just the updated good faith witness list is number 2. Motions in limine, updated good faith witness list. We're talking Wednesday before trial. The last thing is this. This is the law you were talking about. The parties will file jury instructions. That's the rules of law that you want me to instruct the jury on.
Mhm.
You'll give me your proposed jury instructions.
Mhm.
It works like this in every case, again, with or without an attorney. The parties must confer, talk with each other, and together agree, if you're able, agree to a set of jury instructions. Typically, parties are able to agree to most of them. Not necessarily all, but most.
Yeah.
If you're able to do that, great. Then the DA will file one set of these stipulated, agreed to jury instructions. Now, importantly, there might be instructions that you want to give, or you want me to give to the jury that the DA disagrees with.
Mhm.
And vice versa. They might say, I think this is appropriate, Mr. Mula. And you might say, I don't want the judge to read that to the jury. So if you have disputed ones you disagree on, each of you, after filing the stipulated set, each of you may file separately what I call disputed instructions. What you want to give, but the DA disagrees, what the DA wants me to give to the jury, but you disagree with. Tell me what that instruction is in writing,
Mhm.
as well as any legal authority, why you think that's legally an appropriate instruction. Some legal authority supporting that.
Mhm.
And usually there are a couple of those.
Okay.
Not many usually, but it's entirely up to you what you want me to
I'll do my
what you
research.
do. Yeah.
Thank you.
Sure.
Appreciate you.
Well, hopefully he rations out his crayons. I did for him to starve to death because he had to use so much of his lunch to create the necessary court documents.
So the Wednesday before trial, motions in limine, those evidentiary motions, 2, updated witness list, and 3, jury instructions.
Thank you.
I'm telling you this in such detail because it's like
A quick
2 weeks
quick
out.
turnaround. Yeah.
Yeah, we're 2 weeks
Yeah.
out.
Yeah.
If
Get on
we're-
it today so that I can get it and file it.
Yeah. And that's why I said my concern earlier about, are you sure you can crank all this out in 2 weeks?
Yeah. I'm good on
Three-
pressure.
three weeks. Okay.
That's where I work the best.
I'm sure you are. Well, here it comes. So that's what I had regarding the dates and times. You understand you got all that?
Yes, sir. Yeah.
Okay. A couple other things. We still have a little bit of talking to do, so I apologize for that.
You're fine.
Discovery. Have you gotten all the discovery from the DA?
No.
You need to get it.
I know.
I mean, not legally. You don't have to.
No, but you have to see the evidence against you.
Yeah. This isn't a surprise thing where the DA
Yeah.
gets to just drop it on you in
Yeah.
front of the jury.
Yes, sir. Yeah.
Have you gone to their office and asked for it yet?
No.
Would you do that today?
Yes, sir.
Okay. So you know where their office is? Right down the hall?
I don't, but I'll figure it out.
Well, it's right here. It's just,
Oh, okay, cool.
if you're in this, if you come out of this courtroom and go down the hall to the back of the building,
Okay.
kind of as that ramp starts to go up towards the back,
Yeah.
away from security.
On the right-hand side,
On
right?
the right-hand side,
Gotcha,
DA's
yeah,
office window, just say, I would like the discovery in my case. Here's my name. Here's my case number. And they won't hand it to you right there. They'll you fill out a little, please, man, get this stuff sheet. And
Yeah.
they'll get it to you as quickly as possible. What I'd like Miss Dancer to do, and I think she's probably doing it right now, is making a note that this is a quick turnaround. And I'm
Yeah.
asking the DA's office to get that discovery to you as soon as they possibly can turn that around.
Thank you.
Discoveries, the police reports, if there is body cam
Yeah.
video in this,
I also have footage myself.
you can
so-
get that. If you have that kind of stuff, that's fine.
Yeah.
So I just want you to get on it as soon as possible because that's a huge disadvantage to you if you don't have it.
Yeah. Thank you.
Sure. Okay. The last thing I want to talk to you about is this. I know the public defender got off your case last time. You wanted to represent yourself. I allowed you to do that. Utterly your constitutional right to represent yourself. What I have to do is give you an advisement, a legal advisement under the law. I'm required to do it. If I don't do this, can't go to trial. Your trial wouldn't even count. I
Gotcha.
give you this advisement. I'm also telling you this because some people are offended when I ask them questions like, how far did you go in school? What's your education? It sounds like I'm almost challenging you. Like, are you sure you know what you're doing?
Yeah.
And I don't want it to come across offensively. I'm just literally required to check on these things to make sure I think you're good to go yourself.
Yes, sir.
Okay.
Yeah.
So bear with me for that.
No, you're fine.
You understand, of course, that you have the right to have an attorney in this case.
Yes, sir.
And that attorney would represent you throughout the case, throughout the trial, even throughout an appeal. If you wanted to appeal, you could have an attorney represent you.
Yes, sir.
A free attorney to represent you from the public defender's office. Ask for that again. I would do that today.
Okay.
And you would have an attorney. You understand that, right?
Yeah, I mean, honestly, if you can hire someone as counsel, like I said before,
I could hire somebody, but I could appoint an attorney to
yeah,
represent.
I'm sorry. Yeah, if you could appoint someone as counsel, that would be great to work through this.
So nobody's going to do a trial in 3 weeks.
Okay. Yeah, you're
So,
right.
so if you want a quick trial, I could promise you, you could hire somebody. Might feel like they could get up to speed that quickly, but I could promise you the first thing the public defender would do is say, Judge, I need to move that trial a couple months.
Huh.
I could tell you because it happens when they get on the case.
I'll get in touch with the DA about it moving forward, but I will go ahead and move forward with me representing myself.
Oh, so now you're going to do your own research. Where have I heard that before? Oh, right, basically every flat earth video I've ever covered. The guy who insists the earth is a flat plane always seems to know it for the same reason, because he did his own research.
Okay.
Yeah.
If you change your mind, I got to tell you, let me know immediately. I will get you the attorney and we'll almost certainly get you some new dates.
Well, like I said before, that I had the other attorney call me, and then so I had to fire the attorney that you hired me,
Yeah.
and then I let them know that this was like a court paid for attorney,
Yes.
and they were like, "Oh no, we want $6,000 up front." So it was just kind of this like they didn't let me know that they weren't representing me for a thing, and it wasn't worked out beforehand. So yeah, so that's what happened there. I don't know if I explained that the last time
We talked a little bit about it. I didn't quite get that deep.
Yeah.
So you want to proceed with keeping it set for trial with
For
you representing
just
yourself?
me. Yeah. Yeah.
You got it.
Yeah.
Okay. You know the charges. I think we covered 2 of them. You got a petty offense, trespass, worst case punishments up to 10 days in jail, and the obstructing a peace officer, worst case punishment up to 120 days in jail. Any legal training or education for you?
I mean, just what I've picked up on my own, just my own research, my own education. Yeah.
Got it.
I don't really, I've been to college. I dropped out at year 2 and just started working at a bookstore and consuming all the information I could get my hands on.
So kind of self-taught, some basic legal principles and knowledge.
Yes, sir.
Have you ever done a trial?
No.
Ever represent yourself in another case?
No, I always had a lawyer, so.
He was this close to hiring an attorney, and at least proving his IQ is somewhere in the upper teens, and yet still so far away. Life must be tough when your intelligence is roughly the same as your shoe size.
I apologize for this question that might be offensive to you. You're not under the influence of any medication, alcohol, or substances today?
I'm 8 years sober and don't take anything. So
Yeah. Well, congratulations
Thank
on
you.
that.
Thank you.
Obviously, you seem perfectly fine to me. I just have to ask the question, like I said.
Yes, sir.
That's fantastic.
Thank you.
You've already had the public defender on the case, so you've consulted with the public defender about your case prior?
No, there was no
Oh, you
real.
never really had a chance to talk with him?
No.
Do you want to talk with him before you set this for trial?
Are you talking about Mr. Guard? Jeff Guard? Are you talking about the one?
Yes. Oh, you had ADC. That's court appointed. Yes. Did you consult with him?
I did not know.
Okay. Do you want to consult with him before you set this for trial in 3 weeks?
Yeah, that would be awesome. If
You-
we could get together and just have a chat, that would be awesome.
Well, that means we're not going to set it for trial then.
Mm.
If you want time, I'm going to.
Yeah, we'll go ahead and
I'm going to
is
give
there
you
is
time.
there any way that if I am out of town that we could do this like well no we wouldn't even be able to do the trial like virtually.
So I just want you to know, if you want time to talk to Mr. Guard or anybody,
Yeah.
I am going to give you the time. If you,
I'll take the time. I want to be smart about it. I'll take the time.
All right.
We'll go ahead and push it out a little further.
okay.
I'll take the time and I'll talk with him and get the advice. Thank you, sir. I'm sorry about that.
It's okay. So everything I've set up,
We're working it out. Yeah.
we're gonna pause because you're restarting or want to pause on this speedy trial issue. We're going to restart the speedy trial clock today. That 6-month clock over today.
Okay.
Do you understand that?
Yes, sir.
Are you willing to do that to
Yes,
get
sir.
more time to talk to Mr. Guard or any other attorney?
It just seems smarter. So
Okay.
to have all the tools available.
Sure. So what I'm going to do is restart the speedy trial clock today, and that will run through May 24. That's a new date. It's not the trial date. It's just the deadline date, May 24, 2026. I'm going to erase all the other dates I gave you.
Sorry.
That's all right. It's no trial
It
date.
just seems now that you said
No
it, it seems
deadline.
smarter. So thank you.
It is smarter.
Thank you.
It is smarter.
Thank you.
And I'm going to set what's called a case management conference. What I'm going to do is give you maybe out till maybe that same week, you're around that week of the December 18, 19
Yeah.
window.
I mean, I'm in town till this is all cleared up.
So I'm going to set it for December 19. The other thing I want to do is information you provided on the application for the public defender. Remember in October, you mentioned your employment status and things like financial status. Remember all that?
Yes, sir.
All generally the same?
Nothing's changed. Nothing has changed besides the fact that I was employed before. I'm not currently employed now.
Okay.
So
I'm
it's
gonna-
only gotten a little worse because of everything going on.
I'm sure he did always have a lawyer until he got his hands on his favorite book, Pro for Dummies. Next voice 9. Thanks a lot, pal. You just brought the average IQ of the unemployment line down by about 50 points.
Reappoint Mr. Guard on your case. Can we do that? Okay.
Okay.
That's the attorney you had before, if I remember. He is going to be officially your attorney as of today.
Okay. As counsel or
You want him as your attorney? You can fire him again.
yeah, no, that's sorry. um we'll appoint him as counsel.
Actually, Mr. Guard had to withdraw due to irreconcilable differences.
Okay.
So I'm not sure I can put him back on your case.
Okay.
So what I'm going to do is this. We'll contact alternative defense counsel generally.
Okay.
And I'll assign an alternative defense counsel to represent your case, represent you.
Okay.
They will be your attorney.
Okay.
If you, after consulting with them, decide you don't want them to represent you for whatever reason,
Yes, sir.
you or they will let me know, and we'll be back here on December 19th,
Okay.
and you will go back to this trial plan that we have.
I can still go ahead and file for discovery on my own?
Yes. Matter of
Okay,
fact,
cool.
I encourage you to do that
Okay.
anyway.
Okay. Thank you.
What do you think of that plan?
Awesome. Thank you. I appreciate your help and all the
Sure.
help with that.
So December 19, I'm going to set it at 9 a.m. in person right back here. I'm going to make a note ADC to be appointed.
I'll work on my legalese in the next
Your,
2
le-
months. Month.
your legally is fine. And if you do go to trial, representing yourself, you don't need to know any legalese.
Okay.
The jury doesn't care, they don't want to hear legalese. And
Okay.
I don't need to hear legalese from you at all.
Okay.
So don't worry about that at all.
Okay.
All right, Mr. Mula, that was a lot of time, but at the end of the day, here's all we did. We reset the case for a case management conference on December 19. That's the last step before we would formally set for trial. December 19, 9 o'clock, right back here. The other thing I did is I gave you a new attorney. I don't know who that name is going to be yet, but they will contact you. Do we have your good info still?
Yeah. Yeah. The number of 558. You can reach me anytime
558. I also have your email at Gmail.
at
Got it.
gmail.com.
All right, we got it.
Cool.
So I've got good contact. You'll get an email. Make sure you don't screen somebody if they're trying to call you or email you. You'll get a call from an attorney hopefully this week. Talk to him, decide what you want to do. Let me know.
Thanks for giving me all the tools.
Yes, sir.
Appreciate you.
Yeah, thanks, Mr. Mueller. Appreciate it. Hope you have a nice holiday or Thanksgiving. We'll see you in December.
Cool. Thank you.
Well, all right then, that wraps up the video. And I have a feeling that once his new lawyer tells him exactly what his old lawyer already said, it's going to be the same story all over again. Now, if you enjoyed the video, feel free to leave a like. If you didn't, leave a dislike. And don't forget to drop a comment below and subscribe to my channel.